Ancillary and appeal in the matter of Mex Group Worldwide Ltd and another, and Cormack and others.
Yes.
My Lords. My Lords, I'm conscious of the time this application has taken already. I hope not to be more than 45 minutes in total this morning between the Scottish documents and the Scottish judgments. My Lords, when we left off, I had just finished my oral submissions on the documents which were said to show Mr. Gollett's interest in CSM. Mr. Grant also said that he wanted to hear some more submissions in relation to paragraph 35 of Mr. Gollett's second witness statement, which I'll come back to.
31.
Sorry, 31, I'm good. The next group of documents are those which Mr. Grant says go to showing who controlled Mex Securities. My Lords, I've referred you to the evidence which I say shows that Mr. Taher was in effective control of Mex Securities, at least until after the consent order was entered into, and this is summarised at paragraph 27 of our Ladden Marshall skeleton argument. Right. We deal with all the documents relied upon by MGWL in our written submissions on this application, paragraphs 26 to 34. I don't have time to go through all of these points. Just one point I'd like to make arising out of my learned friend's oral submissions. On a number of occasions, Mr. Grant expressed surprise that Mr. Ford had anything to do with Mex Securities. One of those occasions was in relation to document 13. Could I ask my Lords to turn up document 13, which is in the Ladden Marshall bundle, page 209. That's tab 9, page 209. And Mr. Grant referred to Mr. Ford saying, I think one can see this on page 209, please give me a call to discuss this email from Colm before he starts flying kites with NASA on options for Mex Securities. My learned friend suggested that Mr. Ford's involvement was illegitimate, saying something along the lines of what on earth's he got to do with it, who knows. But in fact, my Lords, we can see on the face of the document itself what he has to do with it. The chain starts on page 212. This is an email from Mr. Duthie to Mr. Nassar Tahir, dated the 3rd of October 2020, copied to Mr. Ford and Mr. Yahya Tahir, in which Mr. Duthie says, Stuart, so that's Stuart Ford, and I had a long and detailed conversation today about possible finance options for Multibank Group based on the Multibank FX strategy. And set out 3 options. 1, a new note issued by Mex Securities. 2, monetization of the FX strategy. 3, corporate bond for the Multibank Group. And the email closes. Stuart suggests that we arrange a call this week to discuss these options. So, my Lords, Mr. Ford is involved because he is, as Multibank well know, providing advice on various financing options, including ways in which Mex Securities might be used. We don't know the ins and outs of Mr. Ford's involvement with Mr. Tahir or Multibank, nor do we know why Mr. Ford said what he said to Mr. Duthie about Mr. Smith flying kites. But it's entirely possible that it was just an exercise in client management, and in my submission that would seem consistent with the chain. What is clear is that Mr. Smith is under no illusion that Mr. Tahir is in charge. One sees that at the bottom of page 209, where Mr. Smith says, 2 lines down, so starting hi Adam, I can get everything set up, we need to see what decision NASA has made, if any. And my Lords, just in terms of the dates of Mr. Ford's consultancy, obviously, as I say, we are not privy to the details of Mr. Ford's relationship with Mr. Tahir and Multibank. But Mr. Yahya Tahir refers to a consultancy agreement between Melville Consulting, through which Mr. Ford provided services, being entered into in June 2018. That I think I referred to yesterday, but for your Lordship's bundle reference, it's supplementary bundle, page 1857, and that's paragraph 59 of Mr. Yahya Tahir's statement. Further agreements being entered into with Regal and Mr. Ford in 2019, That's at paragraphs 60 and 61, bundle reference 1857. My lords should note that paragraph 61 doesn't use Mr. Ford's name. One has to go to the document referred to in the exhibit for that, which is not in the appeal bundle, but which we can obtain if my lords would like to see it. The original consultancy agreement with Melville ending in January 2020, that's paragraph 63, supplementary bundle, page 1858. And the last agreement linking Mr. Ford to Mr. Tahir ending in May 2022, that's referred to in paragraph 76, page 1862 of the supplementary bundle. My lords, as for the documents which are said to show Mr. Gollitz was aware of exactly what was being negotiated in Dubai, I rely upon my written submissions. There is not one document which shows that Mr. Gollitz knew of the content of the negotiations. And as I mentioned yesterday, there's an email from Mr. Wolotovsky to Mr. Gollitz on the 15th of December 2020. Page reference is supplementary bundle, page 234. So that is between the entry into the consent order and Mex Securities transferring the money to Multibank, which appears to have positively misled Mr. Gollitz because he was told that Mex Securities were in the process of instructing lawyers for a claim that had already been settled. Regarding the documents which are said to show that Mr. Gollitz was concerned to keep communications relating to CSM off the Multibank servers, my learned friend did not take you to a single email which showed that Mr. Gollitz was concerned about sending emails to the Multibank servers. And my lords, regarding document 31, and I'd ask my lords just to turn that document up now. So that's again in the Lavender Marshall bundle, tab 9, document 31 is at page 287. My lords, this opens with Mr. Gollitz asking for all correspondence regarding their cooperation and future setup of independent asset management company to his personal address. He says that in the attachments you'll find an updated version of what I want to do in the future with your guys. It is still in the VDH design, but I'll convert it into a neutral design until we have a corporate design. My learned friend says that this must be a reference to CSM, but again they filtered the attachment, which shows that it is not the case. We've provided a copy of the attachment at page 561. It's exhibited to Mr. Gollitz's fifth witness statement, so page 561 of the Lavender Marshall bundle.
561?
561, my lord. My lords, what is described, this is on page 563, is an asset management company. Then at 566, the services contemplated are evaluation of clients' assets, develop an asset mix which suits the client's needs, provide advice on other finance-related issues. My lords, this is not describing CSM. CSM is an SPV which takes money from investors in exchange for notes and uses that money to buy assets with which to service those notes. It does not do anything like what is being described here. An asset management company might invest client money in the notes, but it doesn't issue the notes itself. And the reason why Mr. Gollitz was having this discussion with Mr. Ford is set out in his fifth witness statement to paragraph 14, subparagraph 1, which is bundle reference, the Lavender Marshall bundle reference, page 521. He believed that he was about to be sacked. My lords, returning to document 31 in the Lavender Marshall documents bundle behind tab 9, so returning to page 287. Next in this document, Mr. Gollitz says that he's not heard anything from Mex Securities. So we can see that about halfway down the page. And that is entirely consistent with his position below. He says that we've not heard anything from Gibson Dunn, immediately below that, regarding the potential claim against VDH. My lords, in MGWL's written submissions at paragraph 57, subpara 2, Roman numeral 5, it is said that what was to be inferred was that this claim was the claim against VDH AG assigned to Mex Securities under the consent order, and therefore Mr. Gollitz must have been lying when he said he was unaware of the consent order. In fact, we know that is not the case, as does Multibank. As we explain in our skeleton argument at paragraph 60, Gibbs and Dunn were acting for Mex Clearing, a multi-bank company which was threatening Mr. Gollitz with the claims that were meant to be assigned to Mex Securities under the consent order, but Gibbs and Dunn did not mention the consent order. My lords, it adds to our concern about the way that these documents have been presented, that multi-bank are asking the court to draw inferences which multi-bank knows are simply not correct. After we picked multi-bank up on this in our skeleton argument, Mr. Grant moderated his submission to the assertion that this shows that Mr. Gollitz knew that claims were being levied against him in respect of his alleged breach of the alleged joint venture agreements by multi-bank. Well, yes, my lords, but by January 2021, that was obviously the case, but that is old news. It was in evidence before Mr. Tinkler, and one can see that in the affidavit of Mr. McDermott, in the supplementary bundle, paragraph 70, page reference 1592. I won't take your lordships to that document in the interest of time. Staying with document 31, further down, Mr. Gollitz refers to his desire to agree a fee for introducing business to CSM. So this is on the 15th of February 2021. One sees that's the date of the email. And by reference to the dates, this seems to have generated the document at page 449, which is in the new documents, the later application. I think it's document, sorry, I'll just...
Introducer agreement.
Correct, my lord, yes. So that's document 4 in the later application, page 449.
This is the one we looked at with the 6%.
My lord, yes. Exactly. So we can see by reference to the dates that this seems to have generated this document. One can see that it said that Regal is engaged in distributing bonds for CSM. One sees that on page 450. Michael Gollitz has agreed to support that business by introducing investment into bonds. And the fees are agreed at clause 1.1, as my lord has said, 6%. But 2 points in relation to this, my lords. First, the fact of this agreement is old news. Mr. Gollitz freely volunteered its existence in his third witness statement, bundle reference, supplementary bundle, page 2295, paragraph 30. As I mentioned, my lords, these communications were entered into against the backdrop of Mr. Gollitz believing he was about to be sacked. As it happens, he was not, and so the agreement was never performed. My lords, you can have a high degree of confidence that this was never performed because MGWL have all of Regal's documents, and they're unable to point to any document which shows any payment being made. My lords, as to documents 62, 63, 64, and 65, so that's pages 356 and following, all these show is that an employee of Mr. Gollitz asked questions about Mr. Ford. Mr. Gollitz asked Mr. Ford about those, and a draft reply was provided to Mr. Gollitz, which Mr. Gollitz did not send. It does not show Mr. Gollitz seeking to deceive anyone or endorsing the contents of the draft reply sent to him. Regarding document 34, so this is at page 295, I'd ask my lords just to turn to that document.
23.
Document 34, my lord, page 295.
Sorry, 295.
My lords, this is the document which refers to the targeting of multi-bank being the, quote, objective of the lawsuit. My learned friend poured scorn on Mr. Gollitz's evidence that that was a reference to the demands made by Max Maillet on the 6th of January 2021, rather than the Luxembourg summons presented in March 2021, so after the email was sent. But nothing in this document refers to any allegations in the Luxembourg summons. What it does do is, A, it refers to the demands that have been posted on, that were posted on the 6th of January 2021. One sees that below FE3, the sentence below FE3. And the letter of the demands, for your lordship's reference, so what this is referring to is to be found in the supplementary bundle, page 255. It refers to communications between Multibank and Max Maillet regarding those demands. So, quote, Adam and NASA have been in contact with Max with their proposals. And then it goes on to say the end goal is to return funds to Luxembourg and redeem Michael's investors, i.e. to recover the money, the return of which was demanded by Max Mayer in January. So, my lords, in my submission, the whole message is about the January demand. My lords, we ended yesterday with Mr. Grant warning that he wanted to hear more about what I had to say about paragraph 31 of Mr. Gollett's second statement, which is to be found on page 2038 of the supplementary bundle. So could I ask, my lords, for court to go to those pages very briefly. So this is paragraph 31, page 2038 of the supplementary bundle. Mr. Gollett's writes, I know that Mr. Ford has discussed investment opportunities with Mr. Smith. I do not know whether he's provided any kind of remuneration services to CSM, but I do know that he's conscious of the fact that he's not authorised by the FCA, and I believe he would have taken care to avoid anything which he would have required FCA approval to do. So there, my lords, Mr. Gollett's is open about the fact that Mr. Ford does discuss investment opportunities with Mr. Smith, and he certainly does not deny that Mr. Ford might have some kind of remuneration. He does not know the ins and outs of their arrangements, and in my submission, none of the documents in this application disprove Mr. Gollett's evidence as to what he knew or did not know. He also says in paragraph 31 that he believed that Mr. Ford complied with his ban. Again, none of the documents disprove that. Indeed, as I said yesterday, Multibank has never articulated the precise manner in which Mr. Ford is said to have breached his ban. One would have thought that that was the bare minimum for an allegation that Mr. Gollett's was aware of such a breach. One final point on all of these documents, my lords. My learned friend makes various criticisms of Gollett's 5. That's the most recent statement in connection with the Lavender Marshall application and what it does and does not address. I really must push back, my lords, on those criticisms. My learned friend spoke with some emotion about how hard he found it to prepare his Lavender Marshall skeleton over 3.5 weeks between receiving the documents and serving his skeleton. We had 3 clear days to respond with a substantially smaller team in the week before the appeal. Gollett's 5 was prepared under very, very intense time pressure. And again, my lords, it could not address everything. I have one more point, my lords, in relation to the Scottish documents and the application as regards that. Apart from the fact that we say that the documents would not have had an important influence on the result below, for the reasons that we give more precisely in our skeleton argument, in our written submissions, and or that they don't amount to new evidence, quite apart from that, we say that the application, if granted, would create a fundamental unfairness in this appeal. My lords, the present situation is as follows. MGWL has access to some 13,000 or 12,200, it's not clear which, documents, which have been taken pursuant to searches conducted on the Scottish defendants. My clients, the HK defendants, have no access to these documents. MGWL has been able to review those documents and select those which it thinks assists its case, untrammeled by any obligation to disclose adverse documents or any duties of full and frank disclosure or fair presentation. MGWL has been able to control the documents passed to its English solicitors, such that neither Quillen nor its English counsel team can offer the court any assurances that the 12,100 or 12,900 odd documents which MGWL chose not to transmit to Quillen were not adverse to MGWL's case, or that they are making fair submissions in relation to the documents which they are putting forward. The scope for abuse, intentional or inadvertent, of the above situation is obvious. Neither the HK defendants nor the court can have confidence that the Scottish documents before it have been presented in a way which is not misleading. There are indications that they have not been. We give examples, my lords, at paragraph 78 of our skeleton argument. MGWL chose to put forward only one of the 2 attachments to document 4. The missing attachment is a draft deed of incorporation which shows that Mr. Smith was not to be the sole owner of CSM, contrary to MGWL's case. I'm sorry, I misspoke. Which shows that Mr. Smith was to be the sole owner of CSM, contrary to MGWL's case. MGWL chose not to put forward the attachment to document 31, which is exhibited to the witness statement of Gollitz 5, presumably because it would undermine its assertion that the new business being referred to was CSM as opposed to a new venture between Mr. Gollitz and Mr. Ford. MGWL chose not to put forward the attachment to document 47, presumably because those opinions from a barrister at 3EB are inconsistent with its case that Mr. Ford was acting in breach of his lifetime ban. MGWL's legal representatives' apparent ignorance of who Gibson Dunn acted for has led them to make an entirely misconceived submission in relation to document 31. My clients were able to catch this misrepresentation because they do know who Gibson Dunn acted for, but the Scottish documents are not their documents, and there may be many other misrepresentations which they are unable to correct. My lords, these concerns can only be intensified by the fact that MGWL have been found to have breached its duties of full and frank disclosure before Mr. Justice Lavender. It may be that my lords would rather wait to hear argument on those before forming a view as to the weight to be given to that point. My lords, in these circumstances, granting the applications made in respect of the Scottish documents cannot be said to be in accordance with the overriding objective and its requirement that parties should, as far as practicable, be placed on an equal footing, and they should be dismissed on that basis as well. My lords, moving on to the Scottish judgments. As the court has heard, MGWL has applied to rely on two Scottish judgments, both dated the 17th of May 2024. The first is the petition recall judgment. The petition recall judgment concerned an unsuccessful application by Mr. Ford, Mr. Cormack, Melville Consulting Partners Limited, Melville Consulting Associates Limited, and Regal Consultancy Limited, who are referred to as the Ford defendants, to set aside search orders which have been granted against them. MGWL applies for permission to rely on this judgment by notice dated the 27th of June 2024. The second is the diligence recall judgment. The diligence recall judgment concerned an unsuccessful application by the Ford defendants, not my clients, to set aside diligence which had been granted against them, diligence being the nearest Scottish equivalent to a freezing order. MGWL applies for permission to rely on this judgment by notice dated the 15th of July 2024. My lords, we oppose the introduction of both judgments for three reasons. First of all, the HK defendants were not parties to the determinations made in either judgment. The petition recall judgment was made in proceedings to which the HK defendants were not even parties. The diligence recall judgment concerned a motion by the Ford defendants against MGWL, and its conclusions do not bind the HK defendants. And we rely on the advice of the letter of Harper MacLeod LLP, which is in the Ladden Marshall bundle to be found tab 5, page 37. I'll come out shortly, my lords. My lords, the HK defendants had no role in either motion. Relevant evidence was not served on them. One sees that in the witness statement of Ms. Salim at paragraph 29, Ladden Marshall bundle tab 4, page 31. They were not represented at the hearings, and their position was not considered by the court. My lords, the reason why they had no role in the diligence motion is because the motion had no practical implications for them, as is explained by Harper MacLeod in their letter dated the 10th of July, under the heading The Scottish Commercial Action and Interim Diligence on the Dependence of the Action. Could I ask my lords just to turn that up? So it's in the Ladden Marshall bundle, tab 5, page 37. Well, I think the internal referencing is wrong. Let me just check that's correct. It is tab 5.
Page?
Page 36 it starts, my lord. And I would ask my lords to turn to page 37 under the heading The Scottish Commercial Action and Interim Diligence on the Dependence of the Action. And so what Harper MacLeod says is this: an action in Scotland commences with service. Service of the Scottish Commercial Action was effected on Mr. Gollitz in January 2024 and VDH in December 2023. On the 19th of October 2023, prior to service of Mr. Gollitz and VDH AG, MGWL obtained interim diligence against all defenders, including the 4th and 9th defenders. Interim diligence has proprietary effect but applies to any movable and immovable assets situated in Scotland. We understand from the affidavit of Mr. Gollitz dated the 1st of November 2023 that neither Mr. Gollitz nor VDH AG have any movable or immovable assets situated in Scotland. The warrant for diligence on the dependents of the action therefore had no practical implications for Mr. Gollitz or the DHCJ. They have not therefore sought recall of the warrants for interim diligence. In theory, it would be open to them to seek to make their own applications for recall, but as presently advised, there's no intention to make such an application or any obvious reason for them to do so. My lords, according to the evidence for MGWL in response, that is not enough. What we see in Mr. Hastings' statement, which I'll just read a paragraph from, which is to be found in tab 8, page 152. This is Mr. Hastings' second statement. I'm reading from paragraph 25, subpara 3. It is said, importantly, VDHAG and Mr. Gollitz were aware of the motion for the recall of the warrant for interim diligence and had notice of it. Counsel for VDHAG and Mr. Gollitz attended part of the hearing dealing with case management issues. VDHAG and Mr. Gollitz made a conscious decision not to participate in that part of the hearing concerned with recall of the warrant for interim diligence. In other words, VDHAG and Mr. Gollitz had the opportunity to raise a challenge on the merits in the main proceedings in Scotland, but chose not to take it, but now seek to make that same challenge in these ancillary proceedings. Well, my lords, the last part of that sentence is not accurate. The HK defendants are not seeking to make any challenge to the petition or the diligence in these proceedings. The implication of Mr. Hastings' evidence is that the HK defendants should have forced themselves into the hearing of these applications in order to avoid the risk of a decision being made that MGWL would seek to use against them here. And that approach is plainly back to front. Mr. Hastings says that the HK defendants were represented at a separate part of the hearing dealing with case management issues. I confess, my lords, I don't know whether that's right or not, but it doesn't matter. It's not suggested that we did participate in the motions for recall. The consequence, my lords, is that the Scottish judgments are not admissible in evidence against the HK defendants. We do rely on the rule in Hollington and Hewthorne as reformulated and explained in the Court of Appeal in Rogers and Hoyle. My learned friend, I think, suggested that the Hollington principle doesn't apply to interlocutory matters. He cited no authority in support of that proposition. And in my submission, there's no reason in principle why it shouldn't. Perhaps more importantly, my learned friend tries to get around this on two bases. The first is, MGWL argue that the judge at first instance correctly gave weight to the ex parte decision of Lord Sanderson. And by extension, it is right that he would have given greater weight to these other judgments. My lords, the simple answer is that, and this is a point we address in our skeleton argument on the question of good arguable case, which is the only issue the judge found against us on, and in respect of which we've put in a respondent's notice, is that the judge erred in principle by having regard to the fact that the Scottish court had held at an ex parte hearing that MGWL had a good arguable case. I should say that below, we were clear that the court should not rely on the view on the merits of the Scottish court. And I even reiterated that point. I won't take the lordships to it, but it was on day 3, pages 51 to 52, which is to be found in the supplementary bundle, page 2891. My lord, this was a serious error of principle. I'm going to come to REFCO shortly. The first point is that as made clear by Lord Justice Phillips in VTB Commodities Trading and JSC Antipinsky Refinery, which is in the authorities bundle for the appeal, tab 48, pages 1121 to 1122, an applicant does not obtain any kind of benefit or presumption from the fact that it has managed to persuade a court at an ex parte hearing that he has a good arguable case. This is a necessary rule of fairness, and one cannot disapply it simply because the ex parte hearing in question occurred in a Scottish court, in respect of which, I should add, my lords, we've received no transcript or note of what took place. My learned friend relies on REFCO. To be very clear, REFCO provides no support for MGWL's contention that the judge was right to give weight to the ex parte decision, and the part of the judgment of Mr. Justice Ricks referred to by MGWL is taken out of context. I'm going to go to that decision very shortly. But the point is this, my lords, in REFCO, Mr. Justice Ricks was not considering whether the court ought to have regard to an ex parte judgment in another jurisdiction. There was no ex parte decision or any decision on the merits, ex parte, inter partes or otherwise, from the United States as far as can be seen from the judgment. And that there was a good arguable case had been conceded by the defendants. What Mr. Justice Ricks did was essentially defer to the court seized of the primary litigation in the US on the question of whether freezing relief should be granted, not the court's assessment of a good arguable case, which, as I say, was not an issue in REFCO. The Court of Appeal upheld Mr. Justice Ricks's decision on the basis of an absence of evidence of a real risk of dissipation. However, Lord Justice Morritt and Lord Justice Potter disapproved of Mr. Justice Ricks's approach on the question of inexpediency. And I'd just like, my lords, just to go to REFCO. Your lordships were taken to that decision yesterday. I'm afraid I have to go into it in a little bit more detail. But it's at tab 19 of the Appeal Authorities bundle. So page 272.
Do you know which volume that is?
I think it may be the first, my lord. I'm sorry, I don't think mine were made up in exactly the same way, but
Volume 1.
I'm grateful, my lord, thank you.
Well, I'm afraid mine have no indication on the spine of which tabs are contained within which volume, so without a reference to the volume, I will take longer to find them.
I'm sorry, my lord, and I'll endeavour to provide those references in the future.
Thank you.
It's like Shoreditch County Court.
I'm very sorry, my lord.
Yes. In about 1985.
Yeah.
So, my lords, page 272.
Not the first case in this court in the recent past in which the preparation of the bundle has been shambolic. But I mean, really, if we're going to have this number of bundles and this number of authority bundles, somebody should have put the which tabs from which bundle on the back of them.
My lords, I can only apologise.
Nobody appears to have nobody at all appears to have complied with the obligation to only put 300 pages in each bundle. So I'm gleefully awaiting for all the bundles to start suffering from bundle fatigue, because they've all got about between 400 and 600 pages in them.
I don't think really anything I can say, my lords. I don't wish to pass the buck. We are the respondents. I'm not sure how much in the hand.
But
No.
So everybody knows.
Yes, I'm very grateful, my lord. So
Okay, REFCO.
REFCO, yes. Could I start just in the time available, just referring to the first part of the headnote, which describes the sort of factual matrix here. So I'll just read for the purpose of the transcript. The third defendant, Mr. Zahid Ashraf, undertook foreign exchange transactions purportedly acting as a partner of his family firm, the first defendant, ETC. Those foreign transactions were conducted with the first plaintiff, REFCO. In June and July 1996, Mr. Zahid Ashraf's positions with REFCO were liquidated, resulting in large losses and a debit balance owed to REFCO of some 80 million US. In July 1996, Mr. Zahid Ashraf executed a promissory note in that sum in favour of REFCO, undertook to make payments each month of 2 million. Some of the 12 million was in fact paid, but that left some 60 million outstanding. The plaintiffs applied for a Mariva injunction and sought relief by reference to an alternative claim under a customer agreement signed on behalf of ETC in 1992 by Mr. Mohammed Ashraf, the father of Zahid and the second defendant. The second plaintiff, REFCO Capital Corporation, were involved because the promissory note was assigned to them. The plaintiffs contended that it was to be inferred that Zahid undertook his foreign transactions with the knowledge of his family, his fellow partners in ETC, i.e. his father and his 3 brothers, and that REFCO's claims were essentially a debt-collecting exercise in respect of which the defendants demonstrated a desire to delay and evade their responsibilities. The plaintiffs argued that these responsibilities lay not only on Zahid himself, but on the firm for which he was then the managing partner, ETC, in the name of whom he was trading, and also on each of the co-partners, his father and 3 brothers. The defendants submitted that what Zahid did in the year leading up to the liquidation of his positions in June-July 96 was done outside his authority as managing partner or his powers of attorney, that he was engaged in a frolic of his own and acted without the knowledge or complicity of his family. The defendants further contended that REFCO knew that the defendants were ignorant of Zahid's trading and conspired to keep such trading secret from the rest of his family. The merits of the dispute were before the United States District Court of Northern Illinois, as a result of the first complaint filed on September 29, 1997 by the defendants with the exception of Zahid against REFCO, and secondly of REFCO's answer and counterclaim to that complaint. In that counterclaim, REFCO claimed US 16.1 million under the promissory note and alternatively US 14.1 million under the customer agreement. On December 19, 1997, Mr. Justice Tuckey granted ex parte a Mariva injunction to the plaintiffs, and the defendants applied to discharge the injunction relying on Section 25(2) of the Civil Jurisdiction Judgments Act. I can then, my lords, just pick up at the start of Mr. Justice Ricks's decision, which is at 273, the right-hand column about halfway down. Mr. Justice Ricks delivered the following judgment on March the 4th, 1998. This is an application to discharge the Mariva injunction granted ex parte under the order of Mr. Justice Tuckey on the last day of Michaelmas term, December 1997. It's an interesting and potentially important application as it involves consideration of the new powers granted in April 1997 under the Civil Jurisdiction and Judgments Act 1982, Interim Relief Order 97. That order extends the power to grant interim relief under the Civil Jurisdiction and Judgments Act, not only in relation to proceedings commenced or to be commenced in a Brussels or Lugano contracting state, but in respect to proceedings commenced anywhere else in the world. I've heard interesting, cogent and detailed submissions from counsel on both sides of the argument on this application. I'm grateful for them. I have, however, formed the view that the primary responsibility in this case for considering whether there should be interim relief by way of some form of attachment of assets by some means analogous to what we in this jurisdiction call the Moreover injunction should fall to the US court, which is seized with the merits of the dispute between the parties before me, rather than this court. I'll nevertheless maintain Mr. Justice Tuckey's order as a holding measure long enough to enable the parties to proceed before the US court in any suitable way designed to raise the issue, the grant of interim relief by way of security over assets presently subject to injunction in this jurisdiction. I shall seek to give my reasons for forming this conclusion, but I've mentioned it at the outset for this reason, since it's the basis of my conclusion the court that is seized with the merits of this case should have the primary responsibility of which I spoke. It is the counterpart of that same rationale that this court should abstain as far as it can from any consideration of those merits. It's my intention in giving this judgment to seek to exercise that restraint. I nevertheless have to give my reasons and set out sufficient material to explain the matter, both for the benefit of the parties and also to inform the learned judge in the US of why I'm in effect remitting this matter to her. One then sees on the right-hand column of the same page towards the bottom, so page 274, right-hand column, the merits of that dispute, having described the background, are firmly without any question or argument about jurisdiction before the United States District Court in Northern Illinois as a result of a complaint filed on 29 September. And my lords, if you could just read on to the top of the next page up to what I might describe as straws in the wind. And then over the page, my lords, page 276, having considered Credit Suisse, page 276, just over halfway down on the right-hand column, in the present case, Mr. Brindle case QC for REFCO emphasised Lord Justice Millett's statement at page 878A, that's from Credit Suisse, that in my opinion, it is in my opinion most appropriate that protective measures should be granted by those courts best able to make their orders effective. Viz. The courts of the state where the assets are located. That passage submitted to Mr. Brindle is a strong steer in favour of this court resolving the issues arising on an application for Moreover relief, because the assets in question are present here. We then get to the main part that I just want to focus on, my lords, which is over the page, so 277, left-hand column, about 3/4 of the way down. In these circumstances, it seems to me that the importance of Credit Suisse is that it emphasises the need for caution and the subordinate role of the English court in exercising its jurisdiction under Section 25. Moreover, since the plaintiffs here have still to show a good arguable case for the grant of a Moreover injunction, they must first meet the two minimum requirements for the grant of a Moreover injunction. That is, a good arguable case and what may be glossed as a real risk of the dissipation of assets. And secondly, they must bear the burden of showing that as a matter of discretion, the court should exercise its powers in favour of the grant of an injunction. Mr. G does not dispute, on behalf of the defendants, that REFCO could show a good arguable case. But he does strongly dispute that REFCO can show a real risk of dissipation of assets. He submits, moreover, that the question of whether or not there is such a real risk is intimately bound up with the ultimate overall merits of the case. He also submits that in exercising overall discretion, the court would have to bear in mind submissions and counter-submissions which are again connected with the overall merits of the case. Secondly, Mr. G submits that there's a particular reason, quite apart from anything that was before the Court of Appeal in the Credit Suisse case, why this court should be especially cautious about exercising its powers under Section 25, namely the presence in the Customer Agreement of Jurisdiction clause, which he submits on the facts of this case places the merits of all legal proceedings for interim relief, such as this application before me in the jurisdiction of the Illinois court. Seems to me there's force in each of those submissions. This is not a typical Moreover case where a defendant is accused of participation in fraud or dishonesty, or where a defendant's financial affairs are so structured, for instance, because it's a company which has lost its single or major asset, or because its funds in England are typically purely transient, or because its funds are typically concealed in or switched between entities which lack transparency. The court can readily see that a plaintiff's claim needs the protection that a Moreover injunction can afford it. This is a case where the allegations of complicity are on both sides. The allegation against the defendants is they were authorised or at any rate knew about Zahid's foreign exchange trading and are simply seeking to evade responsibility. The allegations against REFCO is that they were compliant with Zahid's trading, knowing it was to be unusual as to be outside his authority to bind the firm or his partners, and assisted him in concealing it from his fellow partners. In such a case, the court faced with a merely ancillary jurisdiction, if indeed it has any jurisdiction at all in the light of the contractual jurisdiction clauses, should be especially cautious and sensitive to the informed view of the foreign court concerned with the substantive merits. So their view, so the court concerned with the substantive merits, their view on the application. Mr. Brindle submits that there's a real risk of dissipation of assets because he asks me to look at this case through REFCO's eyes as a debt-collecting exercise against recalcitrant debtors. Mr. G, on the other hand, submits that the Ashraf family and their family firm have been betrayed by Zahid and REFCO working in common. Moreover, he submits that on the evidence before me, ETC is a substantial reputable trader in gold trading conducted in London's regular long-standing. The defendant's family cash deposits in London do not have the appearance of funds in search of a hiding place. So, my lords, what Mr. Justice Ricks is saying here is not I have to decide whether there's a good arguable case, but I want the view of the court below as to the substantive merits, let alone...
you mean the foreign court?
The foreign court. I'm sorry, I misspoke, my lord, yes. Yeah. Not that I want the view of the foreign court as to the substantive merits, let alone I want the view of the foreign court, the ex parte view of the foreign court. That there's a good arguable case is not even disputed by Mr. G for the defendants. What Mr. Justice Ricks is saying is that the primary responsibility for deciding whether interim relief should be ordered should fall to the US. So, my lords, I'm sorry that took a while, but the problem is that when one reads that sentence out of context, it could be thought to mean that Mr. Justice Ricks was saying he was interested in the view of the foreign court on the substantive merits. And that is not what Mr. Justice Ricks, in my respectful submission, is saying. And so, my lords, that is why I say that REFCO provides no support for MGWL's contention the judge was right to give weight to the ex parte decision of the Scottish court. My lords, secondly, MGWL rely on the decision of the Court of Appeal in Motorola and Uzan. Again, however, my lords, the observations of Lord Justice Potter in that case need to be seen in context. In Motorola, a worldwide freezing order was sought in support of proceedings in New York pursuant to Section 25 of the Act. The second, third and fourth defendants were not resident in England, and the second and third defendants had no assets in England. Nevertheless, a worldwide freezing order was granted at first instance. It was upheld on appeal against the first and fourth defendants, but was discharged against the second and third defendants. The result was that in the case of the second and third defendants, who had no assets here and were not resident here, the worldwide order was set aside. The fourth defendant was resident in England. Further, the claimant's case against her had been considered by Judge Rakoff in New York at a hearing occupying 6 days, in which the fourth defendant was represented and relied on the evidence of witnesses called on the defendant's behalf. Nonetheless, at first instance, Mr. Justice David Steele held that, before Mr. Justice David Steele, the fourth defendant argued there was no good arguable case against her for the purpose of the Section 25 application. The judge considered that the decision of Judge Rakoff was not challengeable by the fourth defendant in the proceedings before him, but went on to state that even if it was, it's fully made out for the purpose of the freezing order. The Court of Appeal held that the fourth defendant should not have been precluded from challenging the finding of the New York court that there was a good arguable case against her, but that despite expressing the view that the fourth defendant was not entitled to challenge the findings of the New York court, the judge, Mr. Justice David Steele, had gone on to exercise his own judgment in respect of the arguability of the claim, and there was no reason to disturb the judge's decision in respect of the fourth defendant. My lords, if I may, I'd just like to go to that authority. Again, your lordships were taken to it. I think that it will be in the same bundle.
Yes, it is.
I'm very grateful.
Thank you.
So it should be page 324. And so, my lords, if we could just pick up the authority at page 331. This is the judgment of Lord Justice Potter. So just by way of background, paragraph 2, the appeals and applications for permission to appeal before the court have their origins in worldwide freezing orders and orders for cross-examination made against each of the first to fourth defendants in exercise of the powers of the English court under Section 25 of the Civil Jurisdiction Judgments Act 1982. point of principle which lies at the heart of the appeals is whether a worldwide freezing order should be made under Section 25 of the 1982 Act in support of an action in another jurisdiction in circumstances where the defendant in question is neither domiciled nor resident within the jurisdiction and there's no substantial connection between the relief sought and the territorial jurisdiction of the English court. This is an authority I think that we'll be coming back to in connection with the appeal. But one then sees the factual background in paragraph 3. The claimant's a large multinational company involved, together with its affiliates, inter alia in the sale of cellular telephone equipment. The defendants are members of a wealthy and powerful Turkish family who, among other business interests, own a telecommunications company, Mobile, which is the second largest supplier of mobile telephones in Turkey. The first and third defendants are the sons, and the fourth defendant is the daughter of the second defendant. One can see, just in the first sentence of paragraph 4, the US action commenced on the 28th of January 2022. If one then turns to paragraph 10, so page 333, on the 9th to the 18th of April 2002, Judge Rakoff conducted a 6-day inter partes hearing involving oral testimony, though not from the defendants personally, upon the claimants and Nokia's application in the US action for preliminary injunction and attachment order. That relief was granted on the 9th of May 2002. In his opinion handed down on the 21st of May 2002, Judge Rakoff stated, "Here we have the unusual case where every preliminary indication is that defendants behind a facade of legitimacy engaged in repeated acts of fraud and chicanery and thereby perpetrated and continue to perpetrate a rather massive swindle. He found that at least $1 billion of the $2.7 billion loans to Telsim by plaintiffs is unaccounted for, with some of it admittedly used for the purpose other than those specified in the loan documents, and much of it seemingly diverted by the defendants for the benefit of Busan Association Enterprise." He further stated at paragraph 12, the plaintiffs have clearly demonstrated they are substantially likely to succeed on the merits of their claims and have further demonstrated that very serious damage is likely to result if the requested relief is not granted. My lords, the decision of Mr. Justice David Steele is referred to in paragraph 81, so page 348. And if I could ask my lords just to read paragraphs 81 to 83. So 348 to 349, paragraphs 81 to 83. My lords, we can then pick up the Court of Appeal decision, and I'd ask my lords to turn to paragraph 102 on page 354, decision of Lord Justice Potter. I'm just going to read paragraphs 102 to 105. We do not go so far as to say, and it's not necessary to decide, that there are no circumstances in which the doctrine of abuse of process could be invoked in relation to points omitted to be taken in prior interlocutory proceedings, whether here or abroad. Mr. Leggett argues that in the context of proceedings under Section 25 of the 1982 Act, whereas here the foreign court in interlocutory proceedings has itself determined that a good arguable case exists against the defendants, that is, or falls to be treated as a final decision upon that issue for the purpose of the Section 25 jurisdiction of this court. We do not think that is correct. The requirement that the claimant must establish that Moreva-type relief would be granted if the substantive proceedings were brought in England requires a decision of the judge based on English procedures and the approach of the English court to the nature and sufficiency of the evidence in a situation where the claimant has come to England to obtain a remedy unavailable to him in the substantive foreign proceeding. It's frequently, indeed usually, the position that Section 25 proceedings are brought following issue and service of foreign proceedings, but before there's been any decision of the foreign court which examines the strength or arguability of the claimant's substantive case. However, whether or not that's the position, in our view, the English court's required, once issues joined in the Section 25 proceedings, to make a separate exercise of judgment, rather than the simple acceptance of the decision of the foreign court in interlocutory proceedings decided on the principles applicable, the evidence then available, and the levels of proof required in that jurisdiction. I think I can perhaps then just go straight to paragraph 105, my lords. All that said, it is quite clear that the judge went on to consider the merits of the arguments raised by the fourth defendant in relation to which he was entitled, as he clearly did, to take the 5 points which it identified into account when assessing the strength and credibility of the fourth defendant's assertions. Where there is available to the judge on application under Section 25 a reasoned judgment of a foreign court at an interlocutory stage upon the merits or arguability of the defendant's claims, that judgment will inevitably form the judge's starting point in relation to the question of a good arguable case. And depending upon the apparent cogency of the reasoning and the force of any arguments raised by the defendant, it is likely to prove conclusive. In this case, it's apparent that the judge, having first expressed a view that the fourth defendant's stance amounted to an abusive process, nonetheless went on to consider and exercise his own judgment in respect to the points raised before him. A number of arguments have been urged upon us to show that he reached the wrong conclusion, but no error in reasoning has been demonstrated, and we see no reason to disturb his decision in respect to the fourth defendant. So, my lords, the observation of Lord Justice Potter needs to be read in context. The fourth defendant took part in a 6-day inter partes hearing involving oral testimony in New York. She was represented and relied on oral evidence of witnesses called on the defendant's behalf. My lords, in my respectful submission, what the Court of Appeal and Motorola were not advocating is the position being advanced by MGWL, which is judgments of foreign courts in respect of applications in which defendants legitimately took no part and had no reason to take part, later being deployed against them in connection with Section 25 applications. I can deal, my lords, more briefly with the second and third issues insofar as the Scottish judgments are concerned. I'm sorry, I'm going a little bit over the 45 minutes that I said I would be. I will be very brief. So the second is that the issues before this court and before the Scottish court are different. MGWL claimed that the inquiry which this court is engaged in and the inquiry which the Scottish court was engaged in are the same, i.e. whether MGWL has a good arguable case and whether MGWL breached its duties of full and frank presentation, but they're wrong to do so. As for MGWL's suggestion that Lord Sanderson's petition recall judgment somehow has a bearing on the issues of full and frank disclosure before this court, my lords, MGWL misses the fundamental point that the issue before the judge below was whether MGWL complied with its duties of full and frank disclosure and fair presentation before Mr. Justice Lavender. Lord Sanderson's opinions as to the quality of the ex parte presentation before Lord Sanderson 2 days earlier, as to which we're in the dark, as I've said, we have no transcript, cannot possibly have any relevance to that inquiry. My lords, I'm not going to turn it up for time, but one can see, for example, from the petition recall judgment of Lord Sanderson, which is in the Ladden Marshall bundle, in particular pages 419 to 420, so 419 to 420, one can see Lord Sanderson expressing a view as to what he did or did not pay regard to at the ex parte hearing. Equally, one can see, so that's paragraphs 45, subpara 1 and 2, one can see from paragraphs 45, subpara 5, that since this was an application for effectively a search order, the BVI proceedings were said to be of little relevance. And at 45, subpara 6, Lord Sanderson had no recollection or note of having been referred to the K2 reports. My lords, in any event, it is apparent that the Scottish law on full and frank disclosure is different to that in England, and one can see that from the fact that Lord Sanderson considered the leading English case on the subject, the judgment of Mr. Justice Carr in Tugachev and Aldrich, and concluded that it did not reflect Scottish law. One sees that in paragraph 44 of the petition recall judgment, page 418. So far as the question of good arguable case is concerned, MGWL are also wrong in 2 respects. First, the question before the Scottish court was whether MGWL had passed the relevant merits threshold in respect of the Ford defendants by reference to the arguments made by the Ford defendants, not the HK defendants, by reference to the arguments made by the HK defendants. And my lords, one can see the arguments made by the Ford defendants at paragraphs 18 to 25 of the petition judgment. So that's page 402 of Ladden Marshall bundle and following. They are, broadly speaking, that the case against the Ford defendants relied upon sinister and strained inferences, paragraph 19, that the calls between Mr. Ford and Mr. Smith in December 2020 could not relate to the conspiracy alleged because they were too early, paragraph 20. There were legitimate reasons for the call, paragraph 21. Mr. Ford's communications with Mr. Gollitz were limited to attempting to find a commercial solution to the problems which had arisen in relation to the notes, paragraph 22. Mr. Ford could not be part of a conspiracy to suppress the fact that he was subject to an FCA lifetime ban because it had always been open about his status, paragraph 23. And the reason for the failed bond, which accounts for the lion's share of the damages claim, was the lack of any market interest in multi-bank prior to Feb 2020, long before the consent order or any related litigation, paragraph 24. Those are not the arguments which we relied upon below or raised by our respondents' notice. And secondly, my last point on this is whatever the similarity on language sometimes employed by the Scottish courts, it is clear that the relevant merits threshold are different to that which this court is concerned. My lords, as is explained by Harper MacLeod in the letter to which I've referred your lordships, which is on page 37 of the Ladden Marshall bundle, motions to grant or recall diligence are decided without reference to evidence. One can see this reflected in the diligence recall judgment at paragraph 5, pages 482 to 483, where Lord Sanderson referred to the need to consider the pleadings as a whole and the submissions made by both counsel in order to determine whether the claimant had a good arguable case. That is also reflected in Gillespie, which I won't turn to, but which my lords were referred to yesterday, where there are repeated reference to the role of the court being to examine pleadings and submissions, i.e. not evidence. And I'd refer my lords to paragraphs 12, 13 and 17. And whilst it appears that the judge at first instance in Gillespie did refer to a lack of evidence, we see that in paragraph 6, counsel submitted that that was wrong in paragraph 7, and neither the appeal court nor opposing counsel contradicted him. And this demonstrates, my lord, that the Scottish notion of a good arguable case is qualitatively different to the English notion of a good arguable case, which is intrinsically an evidential inquiry. And in support of that proposition, I'd cite the Niedersachen case, which your lordships will no doubt be more familiar with than I, page 614, column 1, which is in the authorities bundle at page 116. My lords, even in this jurisdiction, the question of good arguable case is occupying this court on a separate appeal. It cannot simply be said that the test in Scotland and here are obviously the same, merely because they both speak of a good arguable case. And as for the petition, Harper MacLeod's evidence is the merits hurdle for such relief is mere intelligibility, which is lower than the Scottish strikeout summary judgment test of relevancy, and that's reflected at paragraph 47 of the petition recall judgment. My lords, I'm sorry that I've been almost 15 minutes over my initial time estimate, so I'm going to, unless I can be of any further assistance, I think end here. I just have one more further small point of sort of housekeeping, I hope, which is that the draft order, the draft Ladden Marshall order, which is to be found in tab 7, page 140, also includes provision for MGWL to rely upon extracts from a witness statement, which is in the Ladden Marshall bundle, tab 10, page 461, but no permission is sought in respect of this document in either the skeleton argument or in the witness statement of Mr. Hastings. We've assumed it was included in error, and it's noted that the statement's only been presented in a heavily redacted form with many pages missing.
Sorry, which page are you referring to?
So the order is page 140, and the witness statement is to be found at page 461 and following of the Ladden Marshall bundle.
461.
My lord, yes. As I say, my lord, it's presented in a heavily redacted form, but it doesn't appear that any application is made in connection with it. But I thought I would just flag that. So, my lords, unless I can be of any further assistance, those are my submissions.
My lords, the only question before this court at this present juncture is whether, using the words of Lord Justice Denning in Ladden Marshall, the new documents would probably have had an important influence, not a decisive one, to use the gloss of Lord Justice Denning, on the result of the case below. Now, it will come as, I suspect, little surprise to this court that, having heard me over a number of hours yesterday, if I had been appearing before Mr. Tinkler at first instance in December with the benefit of these documents, they would have been placed at the very forefront of my submissions as regards the questions of A, good arguable case, which was contentious, of course, and B, risk of dissipation, which is likewise contentious. And I have no doubt that Mr. McGrath would have done exactly the same thing, given that he was counsel below, had he known of these documents. Where the first instance hearing is an interlocutory hearing, not a trial, the concept of, to use Lord Justice Dennings's words, important influence, obviously does not entail the judge below or this court making final decisions on what the documents mean or what they show. The question of important influence, those are being the words of Lord Justice Denning, go to simply two questions. Do they buttress a good arguable case at what is necessarily a provisional stage in the forensic process? Do they buttress a real risk of dissipation? Again, a provisional question which cannot be finally answered because it is necessarily being asked at an interlocutory stage without cross-examination. The question is emphatically not, do those documents prove the underlying case?
No.
Because this is not a trial. This is an application for an interlocutory injunction below, and this is an application to bring in evidence to, which goes to, we say, that decision which the judge below had to exercise, and which he exercised through no fault of his own, with blinkers, because Mr. Gollitz had chosen not to put before Mr. Tinkler a whole host of documents which we have now found through the search order process, which we say are highly material to the decisions that the judge below had to answer.
And of course, it is striking that insofar as the documents which are to or from Mr. Gollitz, he's got them anyway.
He has them anyway.
In the context of these proceedings, and assuming these proceedings continue, he will have to give disclosure of them in due course.
Well, he's got them anyway. The bulk, essentially the documents which we have placed before this court fall into two broad categories. Category one are documents going back and forth between Gollitz or to which he's copied in.
Yeah.
He's got those documents. He's chosen not to deploy them. He's put in witness evidence and has held them back for his own, no doubt, for forensic purposes. And I'm sure my learned friends never saw those documents, because if they'd done so, they'd have felt professionally obliged to put them before Mr. Tinkler below. No doubt about their professional obligations, had they seen them. Of course, they didn't see them, because Mr. Gollitz, we respectfully suggest, made a decision to hold those documents back because of their devastating consequences. The other category of document, my lords, are documents that do not include Mr. Gollitz, but they are nonetheless documents which are made between his close associates in respect of matters he was closely associated with. So it's not as if they are documents that are entirely alien to him. They relate to decisions, conversations, discussions, which he was, broadly speaking, a party to, even if he wasn't actually a recipient of WhatsApp X or email Y. Now, my lords, that's, if I may say so, respectfully, a correct observation by the Chancellor. But nonetheless, the way my learned friend has gone about approaching this application is not to actually ask the mandated question of Lord Justice Denning, but instead to treat this as if it were a trial, and to treat my submissions as if I was inviting this court now to make actual findings of a conclusory nature relating to what happened as between Mr. Gollitz, Mr. Smith, Mr. Ford, and so on and so on. But of course, I'm not asking the court to make actual findings, nor would I, had I appeared before Mr. Tinkler with the benefit of those documents, been asking Mr. Tinkler to make actual findings. All I would have been asking the court below, and no doubt Mr. McGrath would have asked the court below to do with the benefit of those documents, is to feed them into the forensic process of answering the questions that were mandated by the Section 25 application. And the whole tenor of my learned friend's submissions over yesterday and today, the hours he spent on responding to this application, were setting up an entirely false target. The target he wants to set up is, this court can't possibly arrive at final conclusory decisions on what document X or document Y actually finally mean, or whether they finally lead to an actual conclusory finding of fact by this court that Mr. Gollitz is a fraudster or this or that. That's not my application, and my learned friend knows that's not my application, but he can't answer it on its own terms. I don't blame him for that. Of course he can't answer it on its own terms, but it's unanswerable on its own terms. Therefore he has to reframe the question in the way that he has done so. Now, I should say, as your lordships will have heard yesterday, I do go quite far on these documents. I do say they are destructive and probably decisive, but I don't need to go that far. And indeed, I'm not, your lordships would be wrong for your lordships to go that far with me because of the very limited role that your lordships are occupying, sitting on an appeal from an interlocutory application, which in turn is an ancillary and subordinate application to a case which is, of course, proceeding substantively in Edinburgh. My lords, the even more bizarre aspect of the resistance of Mr. Gollitz and his company, DHCJ, to this application is that a large number of the documents which we have unearthed are now part of the substantive proceedings in Scotland. I told your lordships yesterday that under a power of adjustment, as it's known, granted by Lord Sanderson, allowing the parties effectively to amend their pleadings, my clients have exercised that right, and your lordships have, I think it's at tab 12 of the Lavender Marshall bundle, the amended condescendence, where we have Mr. Brown, the advocate in Edinburgh, has pleaded out large quantities of these documents, which are, according no doubt to his own professional obligations, he perceives them to be relevant and sufficiently relevant, not to be simply evidence to put place before the trial judge in due course, but to actually plead them. And the unreality of Mr. Gollitz's position, as articulated via his counsel, is that this court should decide the question of good arguable case, which he raises on his respondent's notice, by effectively blinkering itself from the case as now pleaded. So we know the case as now pleaded recites a number of these documents to make good a number of substantive propositions concerning Mr. Gollitz and VDHAG's complicity in a conspiracy. There's not challenged in Scotland, so far as I'm aware, by VDHAG. So that's part of the pleaded case which will have to be met in due course by my learned friend's clients. But apparently in England, we've got to pretend they don't exist. So effectively what my lords are being invited to do by my learned friends is to say that when it comes to his respondent's notice and dealing with questions of real risk of dissipation, this court has to proceed on the basis that the evidence of the evidence before it is as contained in Mr. Gollitz's second and third witness statement, most importantly, of course, his second witness statement. But that would be just remarkable. Because we now know that a lot of those statements in Mr. Gollitz's witness statement are wrong, or at least arguably wrong. At least arguably wrong. But no, cast them aside and decide this case, says my learned friend, on the basis that Gollitz's witness statement, there it is, it's unchallenged, that's the evidence before the court, and yet you know from the documents that have been unearthed that as I showed your lordship yesterday, I went through paragraph after paragraph, and I said, look at what he says there and compare it to the documents we now have. And at least arguably, I say it goes a lot further than that, those statements are entirely incorrect. And my learned friend embarked yesterday upon what I thought was going to be a document by document refutation of our innuendos, not our innuendos, our interpretations of what those documents mean. He obviously took the view overnight, and rightly so, that was an exercise which might not be very helpful to this court, but more importantly, would be a very dangerous exercise for his client to embark upon. Because of course, if you actually look at each document by document, you come across you hit the brick wall of actual fact and the brick wall of gaping and yawning discrepancy between the case and the story that Mr. Gollitz placed before Mr. Tinkler and the true facts. And I'm not going to go through each document again and set out what my learned friend said and set out what I say, because it would be a fruitless exercise, because it doesn't meet the right question or the right test. Your lordships are not being asked to decide finally whether Mr. Gollitz is a conspirator or not. That is a matter for the Scottish courts, not the English courts. All your lordships are being invited to do by me is to say, I present these documents before this court. They pose very, very serious questions for Mr. Gollitz. At the very least, they substantiate a good arguable case, which my learned friend wants you to decide there isn't a good arguable case at all. Just chuck it out. And they also show, at the very least, very serious questions about Mr. Gollitz's honesty, not only in terms of the underlying matters, but also in terms of the evidence he placed before the court below. And if there is a proper case for saying that Mr. Gollitz has given evidence below which was a lie, then that of course is highly material to the question of risk of dissipation, which the court found below, with its blinkered evidence, through no fault of its own, but through Mr. Gollitz's decision to withhold critical documents from the court, found adversely to my case. And my lords, just without wanting to descend yet again into the minutiae of the documents, my learned friend had to skate a very treacherous and delicate path through the documents. He looked at a few with your lordships. I mean, just to take one example without wishing to trouble and bore the court, he took your lordships to document 13, page 209, and I was waiting for the answer to the actual gravamen of document 13, which I think my learned friend will have heard this yesterday. I spent some time saying, what on earth is Mr. Duffy doing, saying to Stuart Ford, oh, I'll make sure that Colin Smith doesn't meet NASA, which of course, the notion that, of course, Colin Smith on my learned friend's case is merely the stooge of NASA. I was waiting for an explanation of that. My learned friend just simply ignored the actual gravamen of the case as I had put yesterday, and the gravamen of the document and the difficulty that the document poses for Mr. Gollitz, and just recast and reconstituted the document in a way that made it easier for him to respond to. Similarly, my lords, I was waiting with bated breath to hear what my learned friend had to say about documents 62 to 65. The documents, your lordships will recall, I spent some considerable time on yesterday, where the inquiring... Sorry. That's document 62, which is page...
I know it has a number that...
No, I know.
In terms of the bundle.
It's a fair...
It's all part of the secret squirrel nature of these documents. So when you refer to a document, please could you give us the page reference?
356, I do apologise. 356. 356 of the external cancellation. Your lordships will recall that this was a series of documents, I'm not going to repeat what I said yesterday, concerning this gentleman, Mr. Schmidbauer, which I spent some considerable time going through, and of course it leads to that document at 368, the reply to send back to Schmidbauer. My learned friend spent, 30 seconds on these documents? I understand why he spent 30 seconds on them, because any time spent on them by him trying to explain them would be devastating. Your lordships may recall yesterday I said that it was a rare case where one finds the conspiracy actually written out, 369. My learned friend's answer to that was, oh, well, this is not a document that Mr. Gollitz himself created. Well, we don't know it is or not. That's a contentious question. But you know, he didn't necessarily agree with what was said there. Well, that's just not good enough, with the greatest respect. I don't blame my learned friend. He's got a difficult job to do. I quite understand that. But if he's going to say to your lordships, as he does, apparently, keep them all out, they don't even meet the Lavender-Marshall test, then one would expect him to provide an answer as to why the words at paragraph 1.3 in this document at 369 do not constitute, as I suggested yesterday, the conspiracy, or at least an aspect of the conspiracy, laid bare between the conspirators, a document they hoped would never be seen, no doubt, by my clients, and then, of course, the sacking 5 days later of the unfortunate Mr. Schmidbauer is ignored entirely. I don't blame my learned friend, but it's no good, my lords, in my respectful submission, standing up and spending 3 hours, as my learned friend did, arguing that these documents should be simply kept out of this appeal forever on the basis that they do not meet the relevant part of the Lavender-Marshall test, and then not actually engage with the documents and not show why each one of them would not have had, or would probably not have had, to use precisely the words, an important influence on the court below. So, my lords, what I say is they plainly meet that test. They are plainly documents of the most serious nature, and it would be quite wrong and quite unfair and lead to a potentially quite unfair outcome were your lordships, having seen these documents and having had quite a good deal of time looking at them, to simply exclude them from your lordship's judicial mind. Now, my lords, I wanted to spend just a little time on a few other points made by my learned friend yesterday. Now, the first 40 minutes of his presentation yesterday were set out as a set of so-called background submissions. I remain entirely in the dark as to how they were relevant to the Lavender Marshall application. What they appeared to be, no doubt made on instructions, was a wholly unfair attempt to litigate a different case to the one before your lordships, or indeed the one before the Scottish courts. Essentially, it read like the opening of a trial where my client's the defendant and VDHAG is the claimant. It was some sort of simulacrum of the BVI trial being opened. Your lordship was shown this document and that, and oh, this shows the conspiracy and this shows the collusion. Of course, there are literally hundreds of pages of pleading in BVI dealing with the substantive questions which were to be tried in the BVI until VDHI went bust and apparently is no longer, well, I don't know what it's doing, but it's certainly not pursuing these proceedings at the moment. My learned friend no doubt understood that making these submissions, this sort of little mini opening in a mini trial, which is not even before the English or Scottish courts, would somehow, no doubt his clients hoped it would somehow blacken my clients before this court, and he must have known that that was not an appropriate thing to do in circumstances where I don't have time, I wish I did, to go through that case and show why it's fundamentally wrong. I just don't have the time. It's not the time and place for this court to be deciding a trial between different parties in a different jurisdiction, viz. BVI. My lord, I am bound to say to your lordship one thing. My learned friend referred to certain transcripts of conversations between Mr. Tahir, Mr. Duffy and Mr. Smith, which he said showed that collusion, and he took you to asked you to read 8 pages of the pleadings in the BVI. He didn't ask you to read the responsive pleadings, which go on for many, many tens of pages. What your lordships were not told about that transcript is its origin. And its origin is as follows. My clients taped certain of the conversations, not all of them. This is a small sliver of days of negotiation over that period in December. They taped them and they transcribed them. And having transcribed them, what did they do with them, these supposed conspirators, being my clients? They placed them before the English High Court. And more importantly, or more significantly, they placed them before Mr. Justice Bryan, sitting in the commercial court, when they sought an order in April 2021. Now, my lords, I have some experience of conspiracy cases, and no doubt not as much as your lordships, but I have never yet come across a case where a conspirator has taped, transcribed, and then placed before an English High Court judge the evidence of his own conspiracy. Perhaps there are first things for everything, but it's not the behaviour we would respectfully suggest of a conspirator. Very far from being the behaviour of a conspirator. Now, my lords, I only mention that not because it's of any relevance, I suggest, to this application, but simply because I don't want your lordships to go away with my learned friend's submissions, which are entirely outside the application, in your lordship's mind. The litigation in the BVI was being litigated at substantial, vigorously on both sides. VDHI now seems to have has gone into liquidation and doesn't appear to be pursuing those proceedings. So who knows what will come of them? That remains a live question. But the idea that your lordship should be given the sort of, to use my lord's own phrase, the sort of greatest hits of VDHI's own case, without actually laying out before your lordships the full panoply of the pleadings and the evidence. And my word, the affidavits that my clients have put in the BVI run to tens and scores of pages. My learned friend doesn't show you any of those because, of course, it doesn't suit him. He just wants to blacken my client's name. No doubt on instructions. I don't blame him for a second. He's, of course, a creature of Mr. Collins's instructions. My lords, the other point that I wish to just briefly touch upon is the entirely unfair supposition by my learned friend that somehow the documents that have now found their way before this court have been, to use his pejorative phrase, cherry-picked by my clients. That is completely and utterly false and wrong. The actual position is as follows, and it demonstrates total and conspicuous propriety on the parts of my clients, solicitors in Scotland, and I hope lawyers in England. What happened, as is laid out in the evidence, is that 12,000, whatever it is, documents were presented and provided to my client's Scottish lawyers in June, as your lordships know. They knew that there was a deal of work to do if there was any hope that these documents could be put before this court by way of Lavender Marshall application. And they worked with extraordinary, as I've said before and I repeat again, diligence to try to work through those documents. Now, the exercise of reading the 12,000, whatever number it is, it doesn't matter, the 12,000 documents in Scotland was not an exercise carried out by my clients with a view to cherry-picking the best ones and holding back the ones that were negative to them. It was carried out by my client's Scottish lawyers with Mr. Brown involved. And Mr. Brown has confirmed to me, because I was so concerned to hear what my learned friends were saying in their skeleton argument on Friday about this cherry-picking, and he can put in a witness statement to your lordships want to, maybe you're willing to take it from me, having communicated with Mr. Brown. He has confirmed there was no question of documents being suppressed by the Scottish lawyers so as not to give a complete picture. He has confirmed to me that what actually happened in Scotland is that the legal team in Scotland, faced with this task, knowing that they had a relatively short period of time in which to accomplish it, went through those documents. They didn't suppress ones that were adverse to their case. They just found the ones that they thought were potentially relevant to the English proceedings, and they transmitted those to my client. They didn't transmit them themselves, because of course it required Lord Sanderson's imprimatur and order to do so. So they presented them to Lord Sanderson. Lord Sanderson, in fact, by consent of the 4 defendants, made the order, and they were then sent down to England, the 93 documents, and then Quillon, my solicitors, then whittled those down with the benefit of Mr. Wright's assistance, I suspect, from 93 to 68. And no, I don't think anyone suggests that we've held back in England any exculpatory documents between the 93 and the 68. So emphatically, my lords, there has been no cherry picking. There has been a conspicuously fair process carried out at extreme time pressure, a time pressure created through no fault of my client's own, and done by lawyers, and not done by the client saying, oh no, don't show that document because that's not very helpful to us, but do show that. Done by a legal team in Scotland. And my learned friends say, well, we haven't seen the 12,000 documents. Why haven't we seen them? If they wanted to see those documents, they've got every right to ask for them. They just have chosen not to do so. And can you imagine what my learned friend would have been saying had we dumped 12,000 documents on him in the middle of June? He'd have been saying, this is the biggest document dump in history. This is the biggest act of sabotage, legal sabotage in history, had we done that. So it's basically, we're damned if we do, we're damned if we don't, on Mr. Gollitz's own analysis. The fact is, these documents, my lord, they speak very clearly for themselves. And of course, we don't know what else is out there, because we don't have Mr. Gollitz's documents yet. We've only got the documents that Gollitz sent, which passed into the hands of Cormack, Ford, or the companies. We suspect the iceberg is only the sliver of the iceberg, or the small part of the iceberg. But of course, I can't speculate at the moment precisely what may be else out there. And of course, there will be a disclosure exercise being carried out in Scotland in due course, which will no doubt provide a much clearer picture of what actually has been going on. My lords, I'm just looking over my notes because I'm very conscious of of the time. Let me deal finally with Lord Sanderson's judgments, and I hope I can take this relatively quickly. There are three grounds for opposition. The first is that the judgments are not binding on, in some shape or form, the Howard Kennedy defendants, my learned friend's clients. Well, that's not the case, and in any event, it doesn't matter. It's not the case because in Scotland, as my learned friend accepts, the quasi-freezing order was a freezing order granted against all the defendants, albeit only insofar as they had assets that actually might be caught by it. And I think even my learned friend's Scottish solicitors concede that in the letter that my learned friend presented before you. So the fact is, if Mr. Gollitz or VDHAG was to open a bank account in Scotland, I'm not suggesting they will do so, but if they were to do so, then the order would, as far as I understand it, bind that bank account. It's merely as a matter of practicality that it may not have an actual immediate practical effect on the Howard Kennedy defendants. But that's very different from saying the judgment is not binding upon them. At the moment, there is an order, a quasi-freezing order, which would affect any assets belonging to my learned friend's clients, were there to be any in Scotland. So in that sense, it is binding. But as regards this court, and I accept, because my learned friend has done so, and I'm bound to do so, slightly moving into substantive questions within the appeal, but may not be a bad thing. No one is suggesting that these judgments, my lords, are binding on this court, and Uzan does not suggest that either. I'm going to come back to Uzan. And we're not seeking to introduce them here as if they were binding. And of course, what is this application vis-a-vis these judgments? It's as simple as this. We just simply want to place these documents before the court and be allowed to make submissions on them. Not to suggest that they are binding on your lordships as to the question of good arguable case. We simply say they are evidentially valid and evidentially relevant to that question. And that is precisely what Lord Justice Potter, speaking for the Court of Appeal in Uzan, said in precise terms. And, my lords, before I go to Uzan, let me just deal with a couple more points made by my learned friends. He says, well, we didn't attend at the hearing in April before Lord Sanderson. We had no role. We didn't present our submissions. We didn't challenge the order. We may have been present at a particular moment in the hearing, but then we withdrew, and so on and so on. We weren't represented, and so on and so on. My lords, so what? The question before your lordships is simply whether you admit this document into evidence so that I can make submissions on it. And my learned friend's extreme position is you should simply pretend it never happened. You should simply extract it and obliterate it from your judicial mind when coming to decide the substantive questions in the appeal. Of course, my learned friend can make whatever submissions he wishes to make on the weight that should be given to that judgment. But that's not this application now. That's for a later stage in the appeal. All we're seeking to do is present it before your lordships and to allow it to remain, so to speak, on the court record. And the fact they weren't represented, so what? So what? It doesn't go to admissibility. The reality is what Lord Sanderson was doing in those two judgments read together was deciding whether or not a good arguable case had been established by my clients, the burden remaining on them. And of course, it's a single case. It's not a claim in breach of contract against Ds 1 and 2, and they happen to have just brought in Ds 3 and 4 and sued for a different breach of contract against Ds 3 and 4. They're suing for a single conspiracy. And if one reads the condescendence, and in particular paragraphs 35 of the condescendence, your lordships will see that it is but one single conspiracy. And let me make that point, if I may, very, very briefly, by inviting your lordships to pick up the main bundle, and I'm hoping it's in your lordships bundle 2, page 1737, and I'm hoping I'm going to get a tab number.
So that's in
It might be, I think it may be bundle 3, I do apologise. And I should also apologise to my lords collectively for the state of the bundle authorities. That it's not acceptable, I do apologise.
1737.
Tab 89, my lords. This is the underlying summons, the part 7 claim form as I characterised it. And the condescendence is at page 1741. This is in the unamended form, but let's look, we don't need to worry about the amended form at the moment for the purposes of the submission. And if your lordships would kindly turn to paragraph 35, page 1756, your lordships will see a heading, drafted in Scotland, the conspiracy, and then there is a single conspiracy pleaded against all the defendants. And there is a further cause of action, that's the right nomenclature, pleaded at paragraph 38, which is a inducement of a breach of contract by, again, all the defenders, bar the induced party, which is the 11th defender. Now, so therefore there's the two single causes of action collectively advanced against the totality of the defendants. Now, that means what Lord Sanderson had to do if he was to maintain the petition, the search order and the quasi-freezing order, was decide whether or not that conspiracy had been proven to the relevant standard by the pursuers at the hearing in April, and he so decided. And of course it's true that the Howard Kennedy defendants chose not to advance their submissions, but that may possibly assist my learned friend in saying, well, we had all sorts of other points which the 4 defendants didn't make, and if we'd made them, and who knows what would have happened. That's a matter going to wait. Doesn't go very far, I would suggest, but I need to deal with that point now. That doesn't go to weight, doesn't go to admissibility. The Uzan, my lords, was a judgment that was, my learned friend spent a little time on Uzan. I think I may have perhaps I misunderstood the submission, but it seemed to be as follows, that, the paragraph 105, which as your lordships will recall is the paragraph where in terms the Court of Appeal says significant weight should be given to substantive judgments on the, as to the merits in the substantive court. My learned friend then said, oh, well, that was a case where there was a 6-day hearing, there was evidence, D4, the relevant defendant was represented, oh, therefore it's all very different. My lords, paragraph 105 is a statement of principle. It's not, you can only take it into account when there's been a 6-day hearing with lots of evidence and where D4 has been represented. It's a statement of principle, and it's a statement, if I may respectfully say, of obvious common sense. The points my learned friend makes may go to the weight to be given to that judgment, although I suggest very little, but it doesn't go to the admissibility of that judgment or the ability of your lordships to take it into account. My learned friend then made a couple more submissions about different issues being decided, and the Court of Appeal, the court in Scotland was using the phrase good arguable case not to mean good arguable case, but to mean something different. But my lords, I've shown you the second judgment, the short judgment, where in terms Lord Sanderson refers to the relevant test being laid down in the Gillespie case. And I've shown your lordship the Gillespie case, where it is said in terms the test for a quasi-freezing order in Scotland is essentially the same as the Morava test in England. It doesn't get any clearer than that. And Mr. Brown, in his advice below, in his affidavit I should say, in terms said the test to be applied by the Scottish court, both as regards the freezing order and as regards the search order, is in essence good arguable case. So it's clear that the judge below was answering the same question, or for all material purposes the identical question to the question that the court answers, or asks rather, and then answers in England. And my lord, there were, I'm told, large numbers of witness statements served in Scotland, served for that very purpose. And indeed, your lordships have some of those witness statements in the bundle before your lordships. You've got parts of Mr. Ford's statement that was served, I think. You've got parts of Mr. Tahir's statement. This was not some arid consideration of whether the pleadings demonstrated within their own confines a coherent case. This was an evidential hearing which went uphill and down dale, and where the court was effectively deciding the question by reference to the same test as in England. There's a final point on full and frank disclosure. My learned friend says, well, the points raised in Scotland are different to points raised in England. This may be a point really for a later part of the submissions. But what we say is that, and I will say, this may be preempting a submission I'll make in due course, that the fact that the Lord Sanderson maintained the order the orders in Scotland, notwithstanding a lot of exactly the same complaints made in Scotland as are made in England, must be, we respectfully suggest, material to the broad inquiry that this court and the court below needed to undertake, which, without wishing to go into the law of full and frank disclosure, but we've laid it out in our skeleton argument, as to whether or not such breaches there might have been were sufficient to warrant and justify discharge as a whole. And this engages a number of submissions about the subordinate jurisdiction of the English court, which I don't think this is the time or place for me to articulate, because they are submissions more properly to be deployed at a later stage in my submissions. So, my lords, with that perhaps longer reply than your lordships had hoped for, those are my submissions in reply on the Ladder Marshall application, unless I can assist your lordships any further.
I think we'll rise from.
Court rise if able. Please be aware that the live stream will still be running, so if you do want to speak about the case, the door is right outside.
Excuse me. Hi, I saw that this hearing was listed for 3 days, from Monday till tomorrow. Is there going to be another hearing tomorrow? Or?
Potentially deciding on what they say.
Right, okay.
Yeah.
Might be changing in the next few minutes. Okay, thank you. I think Tom might have popped to the toilet, so he might be. I'm sorry.
Sorry.
Court rise able.
Well, Mr. Grant, Mr. Calfon, we've now spent nearly a day and a half on what we were told was a 1 hour application, or what Master Meacham was told, I think, would be a 1 hour application to adduce fresh evidence under Lavender Marshall. If in fact the Court of Appeal Master and the Court of Appeal Listing Office have been told this case was a 3-day appeal with 1.5 days tacked on for a Lavender Marshall battle royal, I suspect that would have been stood out of the list and relisted for some time next term for 4 to 5 days. But we are where we are. As I indicated at the close of business yesterday, this appeal must be finished by close of business tomorrow. The latest we will sit is 4:30 tomorrow. You effectively have just over a day and a half between you. You don't seem capable I'm sorry, I shouldn't say capable, that's offensive, but you don't seem to have agreed a clear timetable between you. So we are going to say that first of all, Mr. Grant, you must present your appeal between now and close of business this afternoon at 4, and we can sit till 4:30, I think. We will sit till 4:30. Then Mr. Calfon will reply to that tomorrow morning. He will then have an hour in which to deal with the good arguable case, and you can reply in relation to that, and you'll do any final reply on your own appeal with a view to the whole case finishing, as I say, by 4:30 tomorrow at the latest. So, as I said yesterday evening, you need to cut your cloth, both of you.
My lord, is the application dismissed or allowed?
So far as the application is concerned, we will allow you to refer to whatever documents you wanted to de bene esse. We will deal with the application in our judgment as part of the overall determination of the appeal.
Thank you, my lords. I should say that in that regard, a good deal of the submissions that I would have made on questions of risk of dissipation, and indeed a reply on the merits of the claim, the question whether it's a good arguable case, have to a large extent been covered,
Yes.
traversed in the
We
ground.
understand that.
Yes,
We do
so I'm not going to be going over the same ground again, and your lordships will understand that. So, my lord, I think the first heading, therefore, that I need to now address your lordships on is risk of dissipation.
Yes.
And the question that is before this court is whether or not we can establish that the court below erred in its assessment of the question of whether or not my clients had established to the relevant standard a real risk of dissipation against these respondents. And your lordships can perhaps please pick up the core bundle to see how the judge below dealt with that question, and he addressed it. It's in his judgment, which is core bundle tab 10, and it is starts at page 131, but I think we can pick it up at paragraph 41 at page 145. That's it, your lordships will see the heading of risk of dissipation. Now, before I consider the way that the learned judge below dealt with the question of risk of dissipation, I wish to frame my submissions with certain, what are likely to be relatively trite submissions before this court about what the relevant law is. And I say that because one of my criticisms, respectfully, of the judge below was that although he mentioned a couple of authorities, he didn't really, he misapplied the test and misapplied it badly, with the greatest respect. So I wish to just make some brief submissions by reference to the authorities on what actually needs to be established by a litigant in my client's position, seeking to establish the relevant risk and to the relevant standard. And my lords, very briefly indeed, and I'm conscious that I'm likely to tread into to potentially excite your lordship's ire when I go to the authorities because of the nature of the bundles, which I can only apologise for again.
Well, somebody's going to have to, I suggest that over the lunch break, somebody from your solicitors puts the tab numbers onto each of our...
My lords, oddly enough, my learned junior had made that sort of suggestion to me to convey to your lordships 5 minutes ago.
So which...
So my lord, it's tab 40, which may be probably volume 3. And I'm going to take this as quickly as I can because this is Hornbook law to your lordships.
Tab 40.
Tab 40, the famous case of Hollyoake and Candy, and my lords, in that case, Lady Justice Gloucester laid down the question to be posed in a paragraph, page 892 of the external pagination, which has been quoted, I think, many times since. And if we go to paragraph 34, 892, your lordship will see the way the test is put at little g to little h. I'm not going to read it out unless it's convenient to the court. Real risk, judged objectively that a future judgment, and so on, and so on. Solid evidence, and so on, and so on. I'm going as quickly as I can because I'm conscious your lordships know this area, of course, very well indeed. My lords, the next staging post is another very well-known decision of this court in the case of Lakatamia and Morimoto, tab 47, which I'm hoping is in the same volume 3. Of course, a judgment that has been cited many times subsequently. And again, if we go to, again, it's paragraph 34. Where page 1100, when Lord Justice Haddon Cave adopted a very influential, if I may say so respectfully, statement of the law by Mr. Justice Popplewell in the Fundo Soberano de Angola case, and he recited it in full, but making one minor amendment to the learned judge, Mr. Justice Popplewell, as he then was his words. At the bottom of the page, I think the words in the original judgment of Lord Justice Popplewell, Mr. Justice Popplewell, are likely to be, I think.
That's clear from the end of the paragraph, if you go to the next page.
Yeah, your lordship's ahead of me, thank you. So it's slightly lowered the test that had been suggested by Mr. Justice Popplewell. So that again is come as no surprise to your lordships. No, lordships don't have seen that many times before.
Yeah.
The next proposition which I advance to the court, which again I think is unlikely to be contentious, is that it has been said many times by the judges over the years that when assessing a real risk of dissipation, the evidence needs to be considered holistically. One doesn't divide it into small chunks and look at each chunk and say, well, does that prove a real risk? What does that prove? One reads and looks at the evidence in the whole and in the round. And for that proposition, we have referred your lordships to a decision. I think there are many citations to similar effect in a case which is at tab 52, which I'm going to be told is in bundle 4. I think. Tab 52, a decision of Mr. Justice Trower 3 years ago. And again, I'm going to take your lordship as quickly as possible to paragraph 43 and 44, page 1283, which I suggest respectfully makes good that point. It may be your lordships don't really need authority for that proposition, but insofar as you are interested in that, then one can see
the
it.
paragraph numbers again.
43 and 44, page 1283. And
Yeah.
the final proposition of law that I respectfully advance to this court is to be found, well, in two authorities we cite in our skeleton. I think we can look at simply the latter one, Keir and Ivory. That's tab, I'm sorry to be jumping around. That's tab 44 of your lordship's bundle, which may well be bundle 3.
Yeah.
Sorry to jump around. A decision of Mr. Justice Nugee, as he then was, in litigation that dominated the courts for some considerable period of time. And
Yes.
the proposition there, which has been said many times before, is that the underlying
Paragraph.
I do apologise, 71 to 73, page 1041.
Yeah.
The general proposition being advanced there, which has been advanced over many cases, of course, over the years, is that the very nature of the wrongdoing itself, alleged by the claimant, can in and of itself give rise to the relevant inferences and allow the court to draw the relevant conclusions to the relevant standard that there is a real risk of dissipation. Of course, there's been quite a lot of learning in this area, and some judges have rightly, of course, counselled against the supposition that the mere fact that there is an allegation of some form of impropriety does not ipso facto lead to the necessary conclusion that a risk of dissipation is established. One needs to qualitatively measure and consider the nature of the allegation.
It's the point that he makes in 73, isn't it, that Mr. Watson was found guilty of deceit. There was ample evidence of using complex structures to conceal and mislead and being uncooperative in relation to enforcement over the judgment. So the use of, I mean, that's a classic. The use of complex structures
Yes.
in itself is not, doesn't establish the relevant risk of dissipation. But if it's complex structures which can be shown to be being used to conceal assets or conceal what the defendant is up to, then that may be of considerable relevance.
That
It all
is
depends on the circumstances.
that is certainly the case. And what I would suggest,
Similarly, paragraph 73, the reasoning seems to be that because the judge has found that there is a good arguable case, then that helps on risk of dissipation.
yes,
Well, I can see that that may well be so in some cases, but if good arguable case is a relatively low standard, the fact that you have cleared that low hurdle doesn't necessarily take you very far in other cases in showing that there's a risk of dissipation.
my lord, yes. Can I, on that very question which my lord raises, can we perhaps just go to one final decision?
Well, I suppose it's because it's a good arguable case that he, his whole, his corporate entity was its entire purpose was to hide his assets.
Yeah, that's one aspect, and we're
Yeah,
not
exactly,
necessarily,
that's why it all.
we're not necessarily in that territory
It's just,
here. Could I just, in answer to my lord's point, can I just show your lordships one final decision, which is tab 30 of the bundle of authorities, which I'm going to bundle 2. You can put away the Kia decision. Bundle 2, and it's another decision of Mr. Justice Haddon Cave, albeit at first instance in that case, called Baldwin and Sheikh Saud Bin, where we go to page 579, and we see a set of propositions laid out by his lordship. I'm not suggesting this is a sort of novel proposition that emerges from out of the blue, and I don't think Mr. Justice Haddon Cave would think it was. But if we go to a set of propositions at paragraph 31, starting at 578, over the page to little 4, this may engage the points raised by my lords. If there is a good arguable case in support of an allegation that the defendant has acted fraudulently or dishonestly or with unacceptably low standards of morality, then it is often unnecessary for there to be a further specific evidence of dissipation for the court to be entitled to take into account there is a sufficient risk. It's all a matter of qualitative assessment, if I may say something which is possibly rather trite. It's all a matter of qualitative assessment, but it's rather important here because the judge, we say, erred substantially with respect in the way he went about asking whether my client below had discharged the burden upon them. And with that mini summary of the law, possibly odious before this court, I turn to the judgment, which I think your lordships may have open in front of you, page 145 of the core bundle. He starts at para 41. He refers to 3 authorities, two of which we've just looked at, without setting out precisely what they say. Then, having made reference to those authorities, at paragraph 42, he purports to synthesize the learning that he has gleaned from those authorities into the proposition we see at paragraph 42, which your lordships will see there. This court has to assess whether there's a real risk of assets being dissipated unjustifiably. In other words, moved to places where they cannot be subject to the jurisdiction or enforcement of the courts to which they could be subject prior to the removal. For our part, we don't understand the last sentence, and we think it's wrong. We respectfully suggest it's wrong, rather, and really rewrites the law in a pretty radical way. And indeed, it may be that if this case had come before the courts in 1978, that might have been a more accurate assessment of the law. But
Isn't he just describing dissipation?
well,
He's not dealing with risk, he's just saying that's what dissipation is.
Well, dissipation can take many different formulations, and it's not necessarily simply moved to a jurisdiction where they are more difficult of enforcement. And there are infinite ways that dissipations can take place. That's my. But my lord, we can see that if we go to paragraph 46, one might get a bit this over the page at 146. There is no money that the claimant says belongs to it or anyone else, that the 10th defendant has been moved, there's a typo there, anywhere, let alone to somewhere where it could not be the subject of an enforcement to which it would currently be subject. Well, that appears to fortify and somehow elaborate the point made at paragraph 42 in a way which we suggest shows that the judge is imposing far too high a test upon my clients. And if we go back to paragraph 43, back to 145, the defendants say the claimant has delayed the bringing of proceedings, shows that the claimant doesn't believe in the risk. The claimant, on the other hand, says that the test is an objective one. The claimant also says that it believes that the defendants pose a risk of dissipation, but there are good reasons why it is not brought now, and that in any event, the defendants may well have dissipated assets since 2002.
is that another typo in line 4 where it says the defendant's belief? Is that the claimant's belief that he really means?
I think that must be another I think that is another typo. It's rather difficult. But I should say that although this was an extempore judgment, the judge then did consider it and then hand down a sort of a new version. When I say a new version, not completely new, but a materially different version to what he'd spoken and read out on the Friday, the 15th of December, after the argument had ended on the Thursday. Then we have paragraph 44. The claimant is correct that the court will apply an objective test. I don't quarrel with that. The claimant's action or lack of action in relation to perceived risk is, however, a relevant matter to which I return below. And then that is the totality of the judge's assessment of what the burden or hurdle that my clients have to face is. Because we know that because going over the page, he launches straight at paragraph 45 into a consideration of risk of dissipation as against the 10th defendant. And as I've shown or endeavoured to show the court, if we read through the paragraphs that follow, it seems pretty clear that what the judge is asking is, have you, the claimant, adduced evidence of actual or attempted dissipation by these defendants already? And that somehow is a burden that my clients had to discharge if it was going to get anywhere close to discharging, to showing a real risk of dissipation. And as I've shown your lordships, if you go to paragraph 46, it seems to be entirely wayward with greatest respect. I mean, it would be a very rare case.
Being made is a slightly different point, isn't it? That this is the point about delay. That because there was a period of time between when you might have made an application for a freezing injunction when you actually did, of over a year, it said, well, there's no evidence that during that year there was any dissipation.
Well, but my lords, it would be a very rare thing. The claimant doesn't have access before the injunction to the finances or the accounts. I'm sorry, you understand.
I think that's all the judge is talking about. Whether he's right or wrong is another matter.
Well, and then we have, but my lord, there is a further gloss at paragraph 46 in the second sentence. The proceedings in Scotland, to which the hearing before this court relates, do not include any allegation of the inappropriate movement of money by the 10th defendant. Now, why is that a relevant question, we ask ourselves? It will be a very rare case where the underlying substantive proceedings include an allegation of inappropriate movement. I'm not saying it never happens, of course, but the suggestion of the judge appears to be that somehow that is possibly a sine qua non of getting over the hurdle, or at least highly material to whether or not my client has discharged the burden.
Isn't the judge at 45 recognising your case that the history of dishonesty of the 10th defendant should lead him to draw the inference that there is a real risk? The point which he answers then at 53 subparagraph 3 by saying that, subparagraph 2, by saying that the allegations of dishonesty don't relate to the dissipation of assets.
Well, very, very rarely will allegations of dishonesty relate to the actual dissipation of assets. And if that was the test of real risk of dissipation, then very few freezing orders would ever be granted in these courts. But if you just if we're at paragraph 53 and turn to 53.1, the 10th defendant is not alleged in this case to have moved any assets, let alone unjustifiably. And one asked, well, why is that a relevant question for the court to ask? How often will it be where an applicant seeks a freezing order that it will be able to show, or let alone allege within substantive pleadings, that a defendant has actually engaged in the movement of assets? That is not the test, and I'm not suggesting it's an irrelevant fact if it can be established, but it is not the test, and it appears to have misled the judge into thinking that there was some higher burden upon the applicant. And I mean, I'm in answering your lordship's questions, I'm dodging around because if one then looks at paragraph 51, where it is thought to be relevant, this is in respect of D10, the last sentence, there is nothing to indicate that the regulator has any concern that the 10th defendant will dissipate its assets. Now, and this is in the context of the regulator, my learned friend said something about this yesterday, that the Luxembourg regulator had written a letter on the 14th of October, which I think your lordships were shown yesterday, where it had listed out a whole compendium of concerns concerning the 10th defendant's discharge of its business. Massive amounts of failings identified by the regulator. But what the judge alights upon is, well, okay, it may have been, VDHI may have been identified as falling short in a very large numbers of ways. But hang on, says the judge, last sentence of 51, there's nothing to indicate the regulator has any concern that the defendant will dissipate its assets. Who's ever heard of a regulator of a company exercising some sort of overview or oversight concerning whether the person regulated or the company regulated is going to dissipate his assets or not? It's we would respectfully suggest a very bizarre sentence to find. And if one reads the sentence, the judgment as a whole, indicates that what the judge has actually, the way the judge has gone about discharging his judicial task is to pose the wrong question, which is essentially, can the claimant show that these defendants have actually been engaged in the dissipation of assets, or can they show that they are on the verge of dissipating asset X or asset Y? That's just not the test with respect. And if it were the test...
Well, that's the point that the judge quotes in paragraph 50 about the submission that was addressed to him on behalf of the claimant, which was effectively the submission that I think, as I understand it anyway, but although the regulator's complaints about the 10th defendant were to an extent historical ones as to past misfeasance.
Yes.
That demonstrated a company culture that wasn't demonstrated to have changed in some way, for example, by new shareholders, new directors, etc.
Yeah,
And therefore demonstrated a propensity to dissipate assets if they had to do so, which is, the sort of classic
quite.
Morava territory.
My lord, can I answer that question? Because essentially, Mr. McGrath below made a number of wide-ranging submissions about this, and one of the submissions he made about D10, who I accept is in a different position now, and I'm going to come back to the fact that the supervening insolvency does require a reconsideration of the question. I do accept that vis-a-vis D10, but looking at it as it was 8 months ago, we had a whole variety of evidence concerning the corporate behaviour of D10. There'd been a scandal a few years earlier. There'd been a particular CEO or managing director who'd been sacked for various defalcations, I think. There'd been then this letter of October 2010, which set out a whole litany of real concerns. And all the judge could find out of that is, well, within those concerns, there's no suggestion that they are worried about D10 siphoning off its assets to the Maldives or to the Marshall Islands, but that would be an answer in 99.9% of all applications for a freezing order. And if it were a good answer, then it would emasculate the jurisdiction and render it just a matter of historical interest, which it's not. It's alive and well and being exercised by these courts, as your lordships will know, and as your lordships have done so yourselves on a daily basis, which is not to say, and it's not my submission, that they are just doled out at the drop of the proverbial hat. I'm not in any way seeking to water down the burden upon me. I'm merely saying, let me have a fair fight on it, and let's consider the question by reference to the actual test rather than the heightened test which the learned judge seems to have imposed. And we can see that even more clearly if we go back to paragraph 53, my lord, because he sets out a number of points. Point 1, I've already dealt with. Point 2, the allegation of, point 2, my lord referred to that. And let me deal with it, address it immediately. There's an allegation of dishonesty against the 10th defendant, but it does not relate to the dissipation of assets or the wrongful movement of any financial asset. But again, that will be a very rare case, and it's certainly not the law that the only relevant allegation of dishonesty that, looking at it through Mr. Justice Haddon Cave's dicta, which of course has been replicated over many judgments, it's not the case that the only relevant allegation of dishonesty which might have evidential weight in establishing the risk or not establishing the risk is an allegation involving the dissipation of assets, because that will be a very rare case. Then we have 3. We have 4, little 4. The courts in the BVI have determined that the 10th defendant need not fortify its position in that litigation. Well, the reason the courts made that decision on appeal, and it's currently subject to an appeal to the Privy Council, but that's by the by, was not because of any intrinsic characteristics of VDHI, but because, as a matter of law, the Court of Appeal in the BVI, or rather the Eastern Caribbean Court of Appeal, had decided that my clients, when seeking to establish we are at risk of suffering very substantial damage by reason of the freezing order obtained against us, had failed, so the Court of Appeal thought, to show that it was the freezing order that was causing the damage rather than the underlying litigation. So it's a completely false point with respect, 53.4. It doesn't relate to the characteristics of D10. It related to the quality of the evidence, or lack of quality, of my clients in seeking to establish fortification of the losses it was said it was going to sustain as a result of the freezing order. And then 5, and this makes my point, 5, little 5. 18 months have gone by, there's no evidence that the 10th defendant has taken any steps since then to dissipate any assets, nor has the claim provided any explanation. Well, how do we know? How does anyone know on the claimant side? And I don't think it's certainly not the case that any of the defendants, and it was Mr. McGrath below used a very vivid phrase here, that the affidavit of merit of assets put in was a snapshot, not a moving video, because none of the defendants said, look, in the year and a half since questions arose, we've maintained our assets, they remain exactly the same as they were, or just by reference to ordinary movements. No, none of the defendants made that point. And what the judge appears to be suggesting there was that there was some burden on my client to establish actual steps taken by defendants to move their assets. And then we have little 6 again, where the same, we would respectfully say, the same error is perpetrated by the learned judge. I then move on to the way he deals with the risk as against my learned friend's clients today.
Just before you do, don't take us to it, but do you simply have the reference to the Court of Appeal Eastern Caribbean judgment?
I don't, but my learned junior does, and I shall give it to you in
It's
30
the
seconds
somewhere.
when he finds it for me. He's a great master of the papers.
And there's an appeal pending to the Privy Council, which is due to be heard or unlikely to be heard because of the insolvency procedure, or what?
Well, the question of the insolvency, of course, throws into doubt whether that appeal will be heard or not. I mean, sorry, that may be the wrong thing to say. I don't know whether it'll be heard. As far as my clients are concerned, VDHI is still, it hasn't discontinued the proceedings. They're simply sitting there in stasis, which is wholly inappropriate and abusive in and of itself, we would say.
Yeah.
Nothing has happened for months now. We've been writing to Carey Olsen, BDHI solicitors, saying what on earth's happening. Carey Olsen are giving us complete poker face response. We don't have instructions.
Yeah.
You know, we don't know, etc., etc.
Yeah.
So we're faced. So we've got pending proceedings in the BVI which are going nowhere fast, and we are obviously having to consider what we're going to do about that. Because as things stand, I mean, the abusiveness of the situation is that my clients are subject not to a freezing order, but I think undertakings we gave in lieu of a freezing order in the BVI. And at the moment, those undertakings are going to be there till the end of eternity because nobody's actually doing anything. But as to your lordship's question, at the moment, we're pursuing that appeal.
Right.
Of course, I don't know what might happen, but we're pursuing it. The answer, my lord, is it's not in the bundle. We put a lot of things in the bundle, but not that judgment. We can provide it if your lordships are keen to see it.
I'll restrain my enthusiasm.
No, but that I think I have.
And is that a different Court of Appeal decision to the one that was the appeal from Mr. Justice Jack?
My lord, there have been the number of Court of Appeal decisions in the Eastern Caribbean is multitude. One could fill out a 3-volume novel with them. Whether it was handed down on precisely the same day or not, I couldn't tell you. There were a number of judgments handed down.
Whilst my lord has asked for that, and that's not in the bundle, I was going to ask whether you had the reference to the judgment in which the Court of Appeal
Recused Mr. Justice Jack.
recused him for apparent bias. That judgment.
That's a very good question. I'm going to defer to Mr. Wright for the time being on that. It's a very fair question. With respect.
Sorry to interrupt. Could I just make the position clear that insofar as the Court of Appeal judgments are concerned, there are probably two. I think they're both in the bundle. The first is where the Court of Appeal recused Mr. Justice Jack. The second is where the Court of Appeal upheld Mr. Justice Jack's finding of a good arguable case. So there are two, but we'll endeavour to provide those. Yes.
Yeah. But if you give us the references at 2 o'clock, that'd be helpful. Yeah. Thank you.
Thank you, my lord. Now I turn to paragraph 54, where the learned judge below considered the question as against my learned friend's clients, and we respectfully suggest that if one goes straight to 55, in this case, the dishonesty allegation was in relation to the 4th and 9th defendants. It's firstly that they were raising untrue allegations to assist in litigation, and so on and so on. And then this penultimate sentence, line 3, these are not allegations of money moving money or of money laundering. So apparently, if you're not making an allegation of money laundering as a claimant against a defendant, you're seeking a freezing order against them, then that counts heavily against your application. Well, if that's the law, then as I say, this jurisdiction is going to wither pretty quickly on the vine. And it just shows, we respectfully suggest, if one reads the totality of the judgment on this, the way that the court below has erred in that regard. And if one just picks up, and I haven't got time to go through the totality of the judgment, if one picks up, then goes to paragraphs 59 and 60 over at page 150, 4th and 9th defendants have been party to the BVI for some time without any freezing order on them. There's no evidence of any dissipation of assets by them, let alone any unjustified dissipation. And I was just pausing there. The 4th and 9th defendants were party to the BVI litigation in this marginal sense, that my clients sought permission to join them, to sue them, not in respect of the allegations in this case, but in respect of their behaviour in bringing to an end the joint venture in early December. So an entirely separate cause of action. They sought permission to join them. Ex parte got permission to serve out. It took a year to serve them out. My learned friend's clients then applied to discharge the order for service out, and that was eventually conceded by my clients last January, or this January I should say. So it's a very narrow foundation that they were a party. I mean, they were technically a party, I accept, but in that narrow way. And my lord, the other points that one sees at paragraph 60. And this engages some of the new documents. I will deal briefly with the assertion made by the claimant that the defendants had a concealed interest in CSM, the eighth defendant. We'd made a number of points about that in Mr. Tahir's affidavit, lines 2 to 4. When taking to those submissions, the allegations by Mr. Tahir did not correlate to the emails. The remaining evidence for this seems to derive from Mr. Duthie. Pausing there, my lord, that's Mr. Duthie telling Mr. Tahir and a solicitor called Mr. Pettiff at a meeting somewhere that CSM stood for Colm, Stewart and Michael. As far as I can tell, the claimant of the defendants all cast significant doubt on what Duthie says, and essentially what the court did there, in ignorance of the new documents, is say, well, what Duthie might have said about, oh, CSM stands for Colm, Stewart and Michael is of pretty limited relevance. You know, Duthie's a loose cannon, everyone says that, therefore I can put that out of my mind. It doesn't show anything. Well, that just gives you an instance of how these new documents actually change quite a lot about this judgment, because if Mr. Tinkler had known and seen the first document of the new Lavender Marshall documents, which my learned friend didn't address at all, quite understandably, that's where Smith tells somebody in November 2020, CSM stands for Colm, Stewart and Michael. So Mr. Tahir's views on that, or evidence on that, proves to be entirely correct. Of course, the judge isn't to be criticised for that, because he didn't have the documents, because they hadn't been shown to him. And then if we go to paragraph 61, which is his summary of the case as against the defendant, the fourth and ninth defendants, again we see the judge applying the wrong test, we say, with respect. Little one, D4 and 9 are not alleged in this case to have moved any assets, let alone unjustifiably. Well, that's going to be a rare case where that allegation will be made. 2, there's an allegation of dishonesty against these defendants, but it does not relate to the dissipation of assets or the wrongful movement of any asset. Well, again, it's a rare case where that will be the case. And it seems to misunderstand the way the law has developed in terms of...
You would say what it does reveal is effectively participation in a corporate structure which they're not prepared to admit they're participating in.
Well, Lord, you're quite right, and you're preempting, as you always do because you're so much ahead of me, preempting a submission I'm going to be making in about 4 minutes' time. But your Lordship is exactly right. The little 3, that allegation is subject to serious litigation in the BVI, and it's certainly not admitted. The BVI courts have determined that the 10th defendant is a good arguable case, that the defendants have not been party to any conclusion or fraud. Well, as has been said many times, good arguable case, there can be a good argument on both sides. I think Mr. Justice Pickens said it famously in Tatneft, and we've given your Lordships the reference to that in the bundle. You Lordships don't need to look at that. No evidence that these defendants have, in the light of the BVI proceedings, taken any steps to dissipate any assets. Well, how on earth could my clients ever establish that? That Mr. Gollitz or VDHAG have been moving assets? The moving of assets necessarily takes place in the shadows. And then 5, the regulator is then resurrected as a relevant concern. Well, how many defendants against whom a freezing order is sought, could it be said of them by the claimant, aha, the regulator has spoken and is concerned that they are dissipating assets? My lords, with the greatest respect to the judge below, he's gone badly wrong. And it's time, your lordships have to reconsider the question ab initio in our respectful submission. And we say that if you look at all the material cumulatively, in the proper way, as set out by the courts, holistically, then the evidence is indeed very strong indeed. Now, I will immediately accept that Mr. Tinkler did not have the full picture. And had he had the full picture, with the picture which my learned friend has fought so tenaciously to suppress from this court and to keep away from this court, I pay credit to him for his tenacity in doing so, then I suspect, and I suggest to your lordships, that the outcome would have been radically different below. But your lordships now have it, at least de bene esse, and I'm not in any way seeking to prejudge any decision your lordships finally make. But I'm making my submissions now on the assumption, merely an assumption, that the evidence is in, de bene esse, provisionally. My lords, I'm going to take each of the respondents in turn, conscious that they interconnect. Now, I take Mr. Gollitz first. Now, this gentleman is the CEO and director of VDHAG. He is the only person who's given evidence on behalf of VDHAG, other than solicitor, I should say. He is, for all intents and purposes, VDHAG before this court. It's not as if there's another evidence saying, well, Mr. Gollitz only has this small role in the company, and in fact, I'm the chairman, or I'm the UBO, and this is the evidence on behalf of AG. The only evidence from AG comes from Gollitz. Now, there are a number of factors which are material to take into account in deciding whether or not Mr. Gollitz poses the risk that should justify the freezing order. The first, my lord, relates to his conduct in December 2020 itself. Now, what we know, and I'm going to ask your lordships to pick up the supplemental bundle, volume 1 now. If your lordships go to a document which I think you looked at briefly with my learned friend yesterday, tab 16, page 169. This is the letter that, in some respects, starts off the general litigation. This is the letter sent on the 3rd of December 2020 to Mr. Tahir, the UBO of my client, saying he's not feeling so good. First, I think that means mentally rather than physically. First sentence. He refers to various matters, and then over the page 170, and then worst comes to worst. I was informed by our fund administrator and the auditor, so very clear, he's been informed by 2 separate entities that there have been recent regulatory changes and we are not allowed to hold instruments that have gold included. Now, your lordship have seen this letter yesterday, but I'm going to spend 2 more minutes on this letter because it's a very important document. This letter, sent by Mr. Gollitz, was a letter which proposed a course of action which we say struck at the very heart of the joint venture, as evidenced by the 2 letters, the letter of undertaking from 2019 and the deed of affirmation from May 2020. It struck at the very heart of the joint venture that had been in operation for some 3 years by that stage. And
let's look at it more closely at 2 o'clock then.
Thank you, my lord.
Court rise and table.